Good morning, Mr. Chairman. Good morning, Mr. Loomis. We are live on YouTube right now, just waiting for everyone else to log on.
Thank you.
Good morning.
Good morning.
Good morning.
Morning, Liz.
Good morning, Russ.
Mr. Chairman, I show 9 o'clock. We do have a quorum present, so the meeting can begin at your pleasure, sir.
Okay, thank you. I did not get a hold of Kathy, so she may still be on her trip. So if she joins, then that'll be great. But we'll start start with the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, and liberty for justice for all. Thank you. All right, today we've got a relatively short meeting. We have one action item, and it's an administrative rulemaking, the existing arm correction, and new commercial use arm. The presenter is Deb O'Neill. She's our acting division administrator for the Parks and Outdoor Rec Division. Deb, do you want to go ahead?
Yeah, certainly. Thank you for the quick change on meeting from last week to this week. I'm thinking that the state has finally fixed the Zoom issues, which is great. So thanks for coming this morning. We just have this one item. We brought it to you at your last meeting to ask to initiate drafting of this rule. And we will, just so you know, we will be changing things up in the future. We'll be bringing the draft at the same time in the future for asking permission to initiate rulemaking. So we don't have to come to you 3 times on this. It'll just be a one-shot deal this first time. So this rule we talked about last time. It serves 3 purposes. It has a date change fix. We inadvertently said June 15th is the end of peak season rather than July 15th. And so we need to fix that. And because it's in the ARM rule, we have to go through the ARM rule process to do that. So since we're opening this up, we decided to add 2 new rules that will essentially fix some things that we don't have the authority to do in ARM. One is to be able to allocate any commercial launches that that might become available because of a variety of reasons, permit revocation, a death of a permit holder, or the sale or transfer to ineligible buyers. And this identifies a way to reallocate those launches. And the other way, the other rule, sorry, is to, it's currently in the biennial rule, and we would like to incorporate it into the ARM. And it would, oh, I'm missing it here. Hold on. Oh, this is a way to incorporate commercial outfitter provisions as in section 9 of the biennial rule. We did receive public comment. You guys have gotten forwarded the public comment that we received. That was through yesterday. We did receive an additional public comment late last night, but it was after the deadline, but I believe he will be on speaking today anyway, so you'll be getting those comments from FOAM and Mr. Mike Bias. And this is not the last time. What we're asking to do is just initiate rulemaking here. We're asking to be able to go through the MAPA process, which also includes a very, very robust public comment period. So the public will have opportunities at least 2 more times to comment on these draft rules. And simply all we're asking you to do here is not necessarily approve the language, but approve us to initiate rulemaking and submit this with the Secretary of State, so there can be an additional public process. If we don't go forward with this, then if you don't vote to initiate rulemaking, then there's no additional public process for this. And I think we all want as robust of a public comment period as we possibly can. So it would be, we recommend that you initiate rulemaking so we can have more opportunity for public involvement in these rules. When we do go through the public process in MAPA, these rules can be amended, and we would bring back the amended rule to you for approval. If you choose not to move this forward to initiate rulemaking, then there will be a date that's in error, and then the provisions in the biennial rule would not be included here, and also we would not be able to reallocate permits if there's any left over. So we do ask that our proposed action is that you formally initiate rulemaking to correct all 3 of these 2 new rules and the date error. And if you have any questions on the actual MAPA process, our rulemaking, or the reasons why, we have Mr. Jeff Hindoin here from our legal unit to answer questions. And I also want to say that the director and chief of staff apologize. They couldn't be here today. They had a meeting they could not miss.
Okay, is that everything then, Deb?
That is, Chair.
Okay, thank you. We'll have discussion from our board members. Does anyone want to start?
Mr. Chairman,
Yes, Member Loomis.
I suppose one question I had probably is, do we currently have any launches that are associated with commercial use permits that are not being issued at this time?
Chair Kipp and Board Member Loomis, no, that is not the case right now.
Okay.
And yeah, Mr. Chairman, and then another question is for, I suppose, for Deb, is do you anticipate that there's going to be some of these permits that are going to be sitting there that are not issued in the future? Is there?
Chair Kipp, Board Member Loomis, you know, if I had a crystal ball, I probably wouldn't be working for FWP right now. No, in all seriousness, you know, FWP gets asked all the time to be proactive in our responses to public needs and to plan for the things that we might not be able to plan for. We tend to be reactive in nature, and that's not the best business model. And so this is just another way for us to be consistent and try to be proactive. You know, it's happened elsewhere, and we just would like to make sure that we have all the T's crossed and I's dotted.
Anything else, Jody?
I'll go ahead, Russ.
We can come back to you. And any other board member comments? Member Whiting, please.
Yes, Mr. Chairman, for somebody at FWP, I guess I'm a little bit curious, seeing we removed one part of the draft language from the biennial rules, why it's back in the proposed ARM rule draft language.
Certainly. Chair Kip, Board Member Whiting, when we brought this to you last time, we brought it in the biennial rule and in a recommendation to include this in the ARM. And during that meeting, you had removed it from the biennial rule, but you did not say we shouldn't remove it from the ARM. So we took that as to proceed in drafting that. So we did, and honestly, it really fits more in the ARM, so it's more secure than in the biennial rule.
Yeah, I understand. That makes sense.
Okay. Liz, was that everything?
I believe so.
Okay. John, have you got anything? You're muted, John. There
Yeah,
you go.
Mr. Chair. I'm not sure I understand this process. So the now if we approve this as is, then you consider the public comments?
I'm
Right
going
then?
to, Chair Kip and Board Member Marancic, I'm going to defer to Jeff to go over the MAPPA process with you. That might be helpful to help you understand how much the public is involved in that process.
Okay, yeah, thank you.
Yeah, Mr. Chair, Member Marancic, yes, what you have before you today is a request for approval of what is a notice of public hearing on a proposed amendment and the proposed, new rules, which are the biennial rule as it sits, plus this proposed reallocation method. That notice would get filed with the Secretary of State if it's approved by the board as is. We then notice up, that gets published in the Montana Administrative Register. There is then a separate public hearing conducted on that notice of proposed rulemaking that we will conduct through Zoom, again, with specific comment period that's, somewhere in the 30-day range. We'll gather those comments back up, conduct that public hearing, and then based on those comments, the department staff, we would then bring you back a proposed final rule for the board to look at that would incorporate all of the public comment received at that MAPPA public hearing, and a proposal for this board to then take action on a proposed final rule, which again, at that meeting would also be another opportunity for folks to provide public comment on whatever the final proposal looked like to you. So there's that to Ms. O'Neill's point, we've got this opportunity for you today to hear public comment on the act of even moving this proposal forward. If it's moved forward into MAPPA, there's yet another public hearing. And then at the back end of that, there would be yet another opportunity for public comment in front of this board when it would be considering the final rule.
Thank you.
And if I may, Chair Kip, one other thing is I might note that because of the stringent timeline for the Secretary of State's filing prior to a legislative year, we were only able to allow about 10 days for public comment prior to this meeting. And if you approve this to initiate rulemaking, that would give the public a lot more time to provide comments than the 10 days we just provided.
Okay, in the future, will there be more than 10 days? Will it be back to the 30?
Yeah, we Chair Kip, we try very hard to do that. Again, the MAPPA process preceding a legislative year is so different than the years after a legislative year. So these timelines tend to be tight prior to a legislative year, but we strive for that 30 days as much as we can.
Okay, thank you. I have a couple questions for Jeff. Jeff, in the proposed draft that we have here, it talks about, you know, in case of a death, reallocating those permits to another outfitter. Well, in our statutes book on page 168, number 3, it says subject to approval by the board, permission or a person designated by the family of an outfitter who is deceased or incapacitated due to a physical or mental disease or injury, or who is unable to carry out the responsibilities of an outfitter due to the outfitter statute, as an active member of military may continue to provide outfitting services for an outfitter expired for an outfitter's unexpired license year, or until the family sells the outfitter business, until the designee obtains an outfitter license. I saw this statute a few years ago with a MOGA member, Rod Stermetz, got really sick and had a brain tumor, was unable to run his business. And these businesses are a family business. The outfitter's name, that license number, is the business, but it's a family business. And his family was able to get an outfitter of record to continue to run their business for that year. Rod passed away. They were able to sell their business. So we have that in statute already. And then at Secretary of State's website, Rule 12.14.121.6 says upon revocation of permits, any rationed units of use that were previously allocated to a permit holder are no longer valid, and the department may reallocate the ration units for use to another applicant. So we have that in statute. So there's a lot of what we're proposing here that I think is already there. I don't know that we need to add this other than change the date mistake. Can you speak to that, Jeff, please?
Certainly, Chair Kip. I don't have my statute book in front of me, but it sounds like what you're referring to is that Title 37 provisions for outfitter licensing.
It is.
Yeah.
It's 37-47-310.
Correct. And what is, short answer to your question is there's nothing about this rule or proposed rule or allocation method that would have in any way, shape, or form impact how that process flow might work through the Title 37 framework. But what's the distinction is we have the Title 37 framework is the Board of Outfitters and Outfitter Licensing. What you as a board and we as a department deal with are commercial use permits. And they aren't the same framework and they aren't the same structure. The Board of Outfitting and its regulations applies to people that are guiding black bear hunters in the Yak and people that are guiding mule deer hunters at Ekalaka and pheasant hunters in northeastern Montana, none of which may have anything to do with an FWP commercial use permit. This system we're dealing with is the one that's tied most closely to our commercial use permits. But to your point, there is a scenario and a way that Title 37 framework can work its way through and end up in a space where our commercial use permits end up being assigned to whoever a new purchaser or transferee of a business is. There's nothing about this proposal that would affect how that would work, would change how that might work. All this is kind of more to your second question, and to what Ms. O'Neill pointed to earlier. It's intended to just provide clarity. To your point, you're correct. And I think Foam made that comment the first time around on this, that with respect to revoked permits, the department may do this. The difference between leaving that in play and adopting what's been proposed is that the department also may not do it. It's discretionary. The proposal would require that the department keep these launches in this pool, same number, and allocated amongst the same matrix of outfitters that sit there today. Without that, you're correct. The department wouldn't have the discretion to do that in the context of a revoked permit, but it would also have the discretion to not do it. So there would be less certainty about the outcome or disposition of any launches that might end up back in the hands of the department through revocation. And to be fair, to go back to Member Loomis's comment, no, there isn't anything imminent we're aware of that are out there, and revocation is a pretty slow process in any event. And also it's been very rare in the other systems. But again, to go back to Ms. O'Neill's point, this is just to propose a framework that says this is what will happen if this happens. It doesn't have any effect on how that might happen or whether it may happen. It may never happen. It's just that's really the only motivation behind the proposal for that allocation frame.
Okay, thank you, Jeff. Board members, any other comments?
Yeah, Mr. Chairman,
Go
just
ahead.
I'm sorry.
Go ahead.
There was another tool in the commercial use rules that allows for outfitters to lease, rent, or otherwise receive compensation from another outfitter for the opportunity to use a Smith River Outfitter launch within a single use season. So that is another tool that can be used between the outfitters. If for example, one outfitter, something were to happen and he couldn't, he had launches, he couldn't, that he couldn't get them all in. And so there's some flexibility within the commercial use rules. So I don't, like one point you made, Russ, I think we're looking at creating a whole new rule to address a problem that has never happened. And so I'm not sure if this particular new rule 1 is necessary. Another point that Board Member Whiting brought up was the change in the language that was in the biennial rule that we passed last time. And we omitted the portion that said dealing with this commercial use rules and transfers, the section said, or the reallocation of revoked or abandoned commercial launches. That was the portion that we redlined. And at that time, I'm thinking about the outfitters and comments at that time. As I recall, at that meeting, we had about 4 people lined up to comment on this. And when we struck that language from that, those 4 commenters dropped out. And my gut reaction was that was the language that the commenters were so troubled with. And now that has been added back in and going back into the ARM rule. So it just gives me pause, and I'd like to hear the board's thought on that.
I guess I'll start. You know, this, I think our board sees some issues here, and we brought them up, and the public comment has brought it up. But what we're asked to do is to move this forward to get the process going where everybody has a chance to comment and be involved. And we hear the word robust conversation. I hope it is. And you know, I have some issues with this, but I'm feeling like I think our job is to start this forward so we don't drop the rule completely and have more problems. We're going to have time to comment. We're going to have time when stuff comes back. We may choose to redline at that point. So I don't like what was put in there because it wasn't in the first draft. The lines or the information that we redlined out of the biennium rule. So I will probably support this to move it forward. Anybody else from the board want to discuss? Okay, Member Whiting.
Mr. Chairman, yes, I kind of agree with your line. I do agree with your line of thinking. I believe the more we can have public involved in the process, the better the rule will be. Again, this is not saying that we're in love with this language and we're going to keep it all the way through, but it does give, as was mentioned in some of the comments we received, that people felt like they didn't have much time to respond. So by pushing it forward and giving people additional time to respond, as well as the department additional time to respond and, decide what hopefully is in the best interest of everybody in our state, I think that's important. So I too will be in favor of keeping this language in to at least move it through the process. Whether or not it's there in the end, I don't know, but.
Thank you.
Mr. Chair.
Member Moranic, please.
Yeah, well, thank you, Deb and Jeff, for helping us understand the process. And I think that yes, we should move this forward and allow the process to unfold. And I agree with Member Whiting and Russ, Member Kip, Chair Kip, 100% that we're going to have time to revisit this and have more public comment, which is really important. So I would agree to move this forward, although I don't agree with all the verbiage at this point.
Okay.
So.
Member Loomis, did you have anything more you want to offer here?
Thank you, Chairman Kip. I suppose my biggest concern that I have is that it's my understanding that there's a lawsuit that is that is happening right now. And I'm a little concerned about moving forward with a rule that may affect commercial use on the Smith when there's a court case. The way I understand it, that is taking place now, that actually is over commercial use on the Smith. I want to make sure that the board is aware of that, and if the board's okay with moving forward on possibly changing or implementing rule change on an issue that is currently in litigation.
Okay, Member Whiting, you have your hand up.
Yes, Mr. Chair, and maybe this, I can only give my opinion and maybe Mr. Hanlon weigh in on this, but I actually think there might be a little bit of confusion or misinformation. It's my reading of this that it actually would not impact. However, I'm not privy to all the court proceedings, but maybe if possible, either Ms. O'Neill or Mr. Handoin could weigh in on if this language would have any kind of direct impact on the litigation.
Thank you. Jeff or Deb, please, can you answer that?
Sorry, Mr. Chair. Yes, I can, Mr. Chair. There's nothing about this proposed rule or this structure that has any bearing or impact on the substance of the litigation matter that's currently pending between the department and one of the outfitters. Again, all this does is propose a mechanism for what would happen in the event launches were to ever end up back in the hands of the department by virtue of being decoupled from a commercial use permit. It says nothing about how that might happen, or more accurately, set up a process for how that might happen. But there's nothing about this rulemaking process, nothing about the board's prior action in adopting a biennial rule that looks identical to this, with the exception of that reallocation method, that had anything to do or any impact on the pending litigation matter. So I think from that standpoint, there shouldn't be any issues on that front.
Okay, thank you. Board members, any more questions for Jeff after his answer to Liz's question?
Chair Kip.
John?
So, but that rule, it doesn't affect anything right now. It's only a draft. Is that correct? I mean, it's not. So what the current rule is what governs right now?
Chair Kip, Board Member Marincek, that's correct.
Yeah, so that I don't know, in my mind, that shouldn't affect that. Well, yeah, but I do agree with Member Loomis that in the future we should probably not rule on this until that court decision is complete. So, but that's my comment.
Okay. Any other comments?
Yeah.
Go ahead, Member Loomis.
Thank you, Chairman Kip. If we move forward with this, I hope that we can have a comment period. Well, this change will mostly just affect the 7 outfitters. It's not, I don't foresee huge public comment on this rule. It affects only the Smith. Right now, there's only 7 outfitters. And I hope that if this process moves forward, that the comment period takes over a certain time that the outfitters are off the river and are able to get engaged in this. I'm kind of concerned that right now we're passing rules, possibly passing a rule, discussing a rule, looking to them for public comment because it affects them more than anybody, at a time when they're all out on the river. They're right in the middle of their season. And I'm hoping that we have this comment period at a time when they're available to study it and contact us and have some input. I would love it if there was some more back and forth between, an opportunity for them to discuss this and go over things and sit down at the table with the agency, and I'd like to hear their input because they have to deal with these rules. We just pass it and then we go back on to another issue. And they know more about this than we do. This is the only, this is like the only regulations that we have, Smith River, as far as float trips. So this is kind of a new issue to us, and I would like to hear from them more on this. So, thank you, Mr. Chairman.
Okay, thanks, Member Loomis. I think we have some people lined up to comment today. I have a question, I guess, for Deb. If we were to move to pass this today as the motion that the department proposes, today is the filing day. Would it go to the Secretary of State's office today and then it would be published 2 weeks from now? And then there would be a 30-day comment period. Can you kind of tell us, give us an idea of that timeline? Should we move forward here?
Certainly, Chair Kip. I am going to defer to Jeff. He knows the timeline much better than I do on the MAPA process.
Chair Kip, yeah, in response to your question, yes. If the board takes action today to approve the draft notice, yeah, it's our intent to get it filed today, and then will be published in the MAR or the administrative register within the next 10 to 14 days. I don't have the timeline specifically in front of me. And then the actual public hearing, the MAPA public hearing, would be July 19th. And we'd have public comment coming in all the way through, written comment all the way through July 22nd. So there'll be about, after this meeting, there'll be more than a 30-day window of additional public comment, and then that second and discrete public hearing that would be held on July 19th.
Okay, a question, I guess, for Jeff there. So today it gets, if we were to move on this, it would get filed, but then it looked like 2 weeks later would be published. Is that published where everybody gets to see it and then they would start commenting on it?
Yes, Chair Kip, that's correct. I think it's July, June 25 publication date. And yes, that is published in the Montana Administrative Register, which goes to anybody who wants to get it. It's out there for the public to see, all types of agency rulemaking processes across the entire executive branch. And a lot of groups just sign up to get notification of that or receive that. So, and obviously our small, to Member Loomis's point, the small group of folks that are most impacted by this and most interested in it are been kept apprised of all the timelines already.
Yes, Chair Kip, I was just going to follow up with what Mr. Hindoin said, is that we've been reaching out to the outfitters and providing them information on when and where they can find information. So we would be sending them this information directly once it was published as well.
Okay. Any other discussion from our board members?
Chair Kip.
Go ahead, John.
So the when these rules are are drafted, but you don't partnership with the outfitters when you're making these rules?
So Chair Kip, Board Member Morancic, we did not, we offer them that opportunity during that public comment period, but they are also free to reach out to us. We do this frequently with lots of stakeholders that we sit down with them after the rules are drafted and during that public comment period to discuss any changes or any concerns that they might have. Once it hits the MAPPA process, though, they have to do that they have to use the formal public comment period to actually make their comments known. But we often sit down with stakeholders on these rules and talk to them about it and talk them through it and listen to their concerns.
Thank you.
Okay. Member Whiting.
Mr. Chair, I feel like we might be ready for a motion.
I think we are. Please, could you do one, offer one for us?
Sure. Mr. Chair, I move the State Parks and Recreation Board authorize the department to file a notice of public hearing on proposed amendment and proposed rules, the Secretary of State, and formally initiate the MAPPA rulemaking process as requested.
Okay, thank you. At this time, we would take comment.
Second.
Oh, I'm sorry.
Yeah.
Yeah, Liz has the motion and Jody second that motion. So now I think it's time for public comment.
Yes, Mr. Chair, if you'll watch my screen there, I'll have the timer up there so that you can follow the public comment. We currently have it set for 2 minutes per person. And we'll start with Brian McGeehan.
Eric, how many commenters do we have?
We currently have 5, 2 with their hands up at the moment.
Okay, thank you. If when you come on, give us your name and who you might represent and where you're from, please.
Hi, my name is Brian McKeon, and I am a Smith River outfitter. I live in Bozeman. Thank you, board members, for your time. I would appreciate the opportunity to make some comment. And I am in support of moving to propose new rules forward. However, I am in strong opposition to the reasons given, the points A and B. Basically, the proposal has 3 parts. One is the corrected date error, no problem there. The second is to move a lot of language that already exists in biennial rule that hasn't changed for well over a decade to standard ARM, and which of course can be changed through other mechanisms later. So no problem with that. The only new language is in new rule item 4, which does address if there was a permit revoked or abandoned, what would happen to those launches. I am also in support of moving that language to public comment. I do support if there were a scenario where a permit was abandoned or revoked by legal methods, that those launches should be made available through another outfitter, and have no problem with proposing how that should happen. I do think it's worthy of public discussion of the mechanisms they propose, but in general, I'm okay with that. What I'm strongly opposed to are the reasons given, additional reasons to revoke launches from outfitters. I do run a family-run business. We do have a lot of existing language related to outfitting permits. If an outfitter should pass away or die or become incapacitated or be serving active military duty, and why the department is deviating from that language related to this commercial use is perplexing and very troubling to me. So I strongly would recommend that in this process, that reason be removed. We have copious language already in our statute to deal with this. I also strongly disagree with the reason B related to when a business sells. We again have statute that protects the rights of outfitters to sell businesses. The role of the state should only be to ensure that a licensed outfitter is overseeing the fishing operations. We have statute that allows a business that's not owned by an outfitter to contract an outfitter as an outfitter on record. All those things exist. And so I'm just really troubled by that. My recommendation is the reasons, starting with the language, apart from permit revocation, other possible circumstances that could result in the availability of ration launches for reallocation would include A and B, that should be removed from the proposal. Thank you for your time, and I appreciate it very much.
Thank you, Brian. Eric, can we another commenter, please?
Yes, Mr. Chairman, we have Mike Geary.
Okay, your name and your who you represent and where you're from, please.
Okay. My name is Mike Geary. I'm an outfitter on the Smith River, the largest outfitter on the Smith River. We are the ones that are involved in a lawsuit, and I would be happy to give you the judge's last order of motion to give some oversight and an overview of not only our lawsuit, but also what he views as overreach by the Parks Department. So I would like this to be tabled, but I have two quick comments. First of all, to Deb O'Neill, I'm unaware of the parks reaching out, but I really welcome that. And so if you would like to have a meeting with the outfitters on the Smith River, all you really have to do is say when and where, and we can make sure that happens. My other comment is the idea of a robust public comment. I think the definition or the idea that a robust comment is created by getting information late on a Friday afternoon, and you have to comment on it by Tuesday at noon. I think that is the opposite of robust. So that kind of rubs me the wrong way. Those are my comments, and I want to thank you.
Okay, thank you, Mike. Eric, do we have any other commenters?
Mr. Chairman, I have John Hertzer.
Okay, John, where you're from, who you represent, please? Go ahead, John. On my screen, I see his hands up and I'm not hearing him.
I'm working on that problem in just a moment, Mr. Chair. Thank you.
Thank you.
Mr. Hertzer, are you there, sir? I have unmuted Mr. Hertzer, Mr. Chairman, but I'm still not hearing anything from him.
Eric, do we have any other commenters? Can we come back to John?
We have no further hands up at this time, Mr. Chairman.
Could you hear me now?
Yes.
Oh, good. John Herzer from Blackfoot River Outfitters, and unlike Mike, I might be the smallest Smith River outfitter. We have 2 launches that I have had for, I don't know, 25 years or something, or whenever they started it. And I just had a quick comment that I really am concerned that this is an issue all of a sudden now. If it doesn't have anything to do with the lawsuit, I don't understand why this allocation is of concern today. So really, the new rule in item 4 is just really unnecessary. There are plenty of other statutes controlling all that, and I think that the board should chair it or should table it. So that's my comment. I reiterate the previous commenters too, Brian and Mike. We both, all of us see it the same way as Outfitters on the Smith. It's only affecting us. It's not really affecting anybody else. And I thank you for your time. Appreciate it.
Thank you.
Mr.
Eric,
Chairman, we have Mike Bias, Michael
yes.
Bias.
Okay, I'm not seeing him. There you
Mr.
are.
Bias, go ahead, sir.
There it is. Can you hear me now?
I can, Michael.
I apologize for that, Chair. My name is Mike Bias, B-I-A-S. I'm the Executive Director of the Fishing Outfitters Association of Montana. We represent 1,100 professionally licensed guides and outfitters across the state of Montana that are commercial anglers. We do support that the board should correct the date mistake in the ARM rule 12.3.650. We would also support at this time a new rule 1 and new rule 2 as written in the proposal only. We would not support any incorporation of additional language that was brought up in the department's reasoning under their proposal or the proposal information sheet that incorporates language concerning the death of a current permit holder or the sale or transfer of a permitted business. Both of these concerns and both of these issues are already covered under the successorship ARM rule under the Board of Outfitters, and that's 24.171.504. And then the law concerning outfitter transfer, which is MCA 3747.310. These are laws and rules that have been in place for a number of years, dealing with exactly the issues that you list in your new rule 1 and new rule 2. Also, FOAM would strongly support a tabling of this rule package going forward, and dealing with this with the incorporation of the Smith River Outfitters and the commercial users, instead of having the department and the board draft rules without our input at all. I thank you for your time, and I appreciate the opportunity to comment.
Thank you. Eric, any others?
No further hands raised, Mr. Chairman.
Okay, before I call for a vote, does the Parks and Rec Board have any other comments or questions?
Yeah, Mr. Chairman.
Go ahead, Member Loomis.
Thank you, sir. The portion that seems to be most troubling is that under new rule 1, I should say most troubling for the comments we've received, under new rule 1, after like the second paragraph after the reason that is giving, that also that would include A and B. Would it be appropriate at this time for us to edit that and strike that language under reason and then move forward with the rest?
If we choose to do that, we'll have to take Liz's motion off the table, vote to move that, and then we'd have to move something forward. Member Whiting, can you comment here, please?
Sure.
Not hearing you. It's not clear.
That both you referenced and one of the commenters referenced, that doesn't have anything to do with the commercial launch permits. Those are two different things. And I think because most of us were wise enough not to go to school, I think we're getting a little bit confused about what the issue is. I am comfortable with moving the language forward at the time being. Not part of our rule. I think we're part of the our rule. I see the issue as
So I'm not hearing Member Whiting very clearly. It's coming and going. Is that the same for everybody?
It is, Chair. It's
Sure.
Yes.
garbled.
darn it, I'm sorry. So I'll just make it real quick. I
If
don't
you
think
Turns her video off. I think she might, her audio might be better.
Yeah, we heard you
All right.
well just last time.
Yeah, turn your video off, Liz.
working on it. All right, we'll try one more time and I'll try to make it quick. I think there is some confusion among the board members and the commenters that the items in Title 37 that have to do with commercial outfitters somehow has something to do with commercial launch permits. Those are two totally different things, unless I'm mistaken. Additionally, the items that the language that says reasons, that's not part of the ARM language. So I think the more important part is the actual language that's going to be drafted, that's going to go for public comment. And I guess my ask and my hope would be that the board, I'm sorry, that FWP could maybe provide like a one-page better explanation of what this rule does and does not influence. Because as I read it as a layperson, because I was smart enough not to go to law school, as I read it, it gives FWP the ability to reallocate permits that for whatever reason have not been able to be used. So if I were an outfitter, I would want the ability to have more float trips instead of less. So at this time, with the information I've been given, I am in favor of moving my original motion forward as I made initially.
Okay, well, we have a motion and we have a second. If we're done with some discussion, with Member Loomis, Member Moranic, are we good there to go ahead and take our vote? Okay. So all in favor of the motion on the table? Liz, can you read that to us one more time, please?
I can, Mr. Chairman. I'm not.
It was the proposed motion on our agenda, wasn't it?
Mr. Chairman, stand by, please. We've lost Member Whiting for the moment.
We've got you back there, Liz.
Sorry about that.
The motion, I think that's on the table. The State Park and Rec Board authorized the department to file a notice of public hearing on the proposed amendments and the proposed rules with the Secretary of State and formally initiate the MAPPA rulemaking process as requested. And then we have a second from Jody. So at this time, I'd like to call for a vote. And we'll start with Member Loomis. Yay or nay, please?
Yay.
Okay, and then District 2 is myself, and I'm a yay. And then District 3 is Member Whiting.
Yes.
Okay, and then District 5 is John.
Yay.
Okay, so this passes with a vote of 4-0. We'll note that Kathy was not in attendance today. So the next item is for public comment on items not on the agenda. Do we have anybody in the queue there, Eric?
I have no hands raised at this time, Mr. Chairman.
Okay, I would offer up something here. I had a citizen that lives near the Clark's Lookout in Dillon. And she was concerned that it's not being mowed and weed-eated and taken care of, and there are signs that are so faded that you can't really see them. She says she knows it gets a lot of use. I thought she was going to be on today to comment or at least send a letter. So just make note that, you know, we've had some concern over that. That's all that I have. Anybody else? Yeah. Jody, were you saying something?
No, I was ready to make a motion if no one else had anything else to say.
Well, let's make that motion.
I move we adjourn, Mr. Chairman.
Okay. Any seconds?
Mr. Chair, I second that motion.
Okay, all in favor, say aye.
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 Okay, thank you guys. I appreciate it.
Thank you.